Article 99 Estate Canon 2022 Estate is a fictional concept first created during the reign of Henry VIII of England through statutes concerning wills and of uses, property, Act of 1540 to describe the existence and collection of two or more trusts within a trust corpus, body corporate or person, of a master trust upon one or more presumptions. Hence the word estate is derived from two Latin words e plus statuo, literally meaning by virtue of decree, statute or judgment. Canon 2023. While only one estate may belong to a trust corpus and trust, an estate may contain potentially an unlimited number of trusts. Therefore, when one speaks of the estate of a legal person, it refers to all and every existing trusts and all possible future trusts that may be associated to the person. Canon 2024. All trusts and therefore property held in estate are aggregated into two categories, being either real or personal. Real estate consists of the first right of use by the estate in land and tenements, also known as freeholds, which traditionally descend to heirs if no will, or if a will exists, to executors and their administrators, and may be subsequently leased to beneficiaries. And 2. Personal estate consists in chattels or movables which go to executors and their administrators, who may then lease them to beneficiaries for use. Canon 2025. The deed and will of a testamentary trust that forms an estate is also known as a constitution or statute. Statute, constitution and estate are all derived from the same Latin root word statuo. Canon 2026. As every estate requires the existence of a trust prior to its existence, an estate can never hold real property. Real estate implies merely first right of use within the constraints of the estate, whereas real property implies the first right of use of a physical object or concept above all other claims. Canon 2027. The term estate is a description of the collection and arrangement of trusts and property within the trust corpus, and so as a term itself is devoid of legal personality. Instead, it is the body, being the trust corpus or legal person to which the estate belongs, that is recognized as a valid legal entity, having legal personality. Canon 2028. The maximum allowable interest of real estate is fee simple, also known as freehold, which may be of potentially infinite duration, a life estate or an estate for a predetermined number of years. The owner of freehold may then typically create smaller estates from their land known as leaseholds. Canon 2029. There are only two modes of acquiring title to real estate, either by descent as an heir or by purchase. When a person acquires real estate by descent, they are considered an heir, and when it is acquired by purchase, they are a purchaser. Canon 2030. Any political body or aggregate known as state is by definition an estate, and must belong to a single trust corpus or legal person, which itself belongs to a testamentary trust in accordance to a particular constitution or statute as its deed and will. Canon 2031. The granting of benefits from an estate to beneficiaries is at the discretion of the executors in accordance with the terms of the deed and will of the estate. A beneficiary of an estate is always the same as a beneficiary of a trust. Canon 2032. When referring to the legal person created within the Roman system upon certain presumptions at birth, the term estate encompasses the body, mind, spirit and all possible existing trusts, properties and liabilities and future trusts created within the Roman system. Canon 2033. While a public trustee within the Roman system may be granted from time to time the position of executor of a trust belonging to the estate of a legal person, by the very definition of estate no agent, principal, trustee or entity may presume to claim the role of general executor of the estate of the legal person, except the flesh, mind and spirit of the being for whom the estate was first created. Canon 2034. When a man or woman acts as a trustee of one or more trusts associated with the estate of the legal person, the office of general executor of the estate is therefore vacant. However, when a man or woman demonstrating competence, wisdom, humility and duty gives public notice as to acceptance of occupying the office of general executor of the estate of the legal person, no other trustee, public servant, agent or entity may usurp their authority concerning the estate. Canon 2035. Any person who seeks to usurp the position of the general executor of the estate and unlawfully claim the office of executor without permission is known as an executor de suntort and may be charged with fraud. Article 100 Sestuike vi Trust. Canon 2036. A Sestuike vi Trust, also known as a fide commissary trust, is a fictional concept, being a temporary testamentary trust, first created during the reign of Henry VIII of England through the Sestuike vi Act of 1540 and updated by Charles II through the Sestuike vi Act of 1666, wherein an estate may be effected for the benefit of a person presumed lost or abandoned at sea and therefore assumed dead after 7 years. Additional presumptions by which such a trust may be formed were added in later statutes to include bankrupts, minors, incompetents, mortgages and private companies. Canon 2037. The original purpose and function of a Sestuike vi Trust was to form a temporary estate for the benefit of another because some event, state of affairs or condition prevented them from claiming their status as living, competent and present before a competent authority. Therefore, any claims, history, statutes or arguments that deviate in terms of the origin and function of a Sestuike vi Trust as pronounced by these canons is false and automatically null and void. A Sestuike vi Trust may only exist for 70 years, being the traditional accepted life expectancy of the estate. Canon 2038. A beneficiary under estate may be either a beneficiary or a Sestuike vi Trust. When a beneficiary loses direct benefit of any property of the higher estate placed in Sestuike vi Trust on their behalf, they do not own the Sestuike vi Trust and are only the beneficiary of what the trustees of the Sestuike vi Trust choose to provide them. Canon 2039. As all Sestuike vi Trusts are created on one or more presumptions based on its original purpose and function, such a trust cannot be created if none of these presumptions can be proven to exist. Canon 2040. The trust corpus created by a Sestuike vi is also known as the estate, from two Latin words e plus statuo, literally meaning by virtue of decree, statute or judgment. However, as the estate is held in a temporary not permanent trust, their corporate person as beneficiary is entitled only to equitable title and the use of the property, rather than legal title and therefore ownership of the property. Only the corporation, also known as body corporate, estate and trust corpus of a Sestuike vi Trust possesses valid legal personality. Canon 2041. The property of any estate created through a temporary, testamentary trust may be regarded as under Sestuike used by the corporate person, even if another name or description is used to define the type of trust or use. Therefore Sestuike use is not a person but a right. Canon 2042. The corporate person being the estate of a Sestuike vi Trust can never be considered as the person for whose benefit the trust is created, but a dead body representing a likeness of the deceased body of the missing person of the beneficiary in whose name the Sestuike vi Trust was originally formed. Canon 2043. As all Sestuike vi Trusts are temporary, testamentary trusts holding estate, a valid certificate or instrument is required to be issued for their birth, technically declaring the true beneficiary dead until their return. If a private company, it is a certificate of incorporation. Canon 2044. Under the fundamental rules of Sestuike vi Trusts, a birth certificate of the body corporate being the estate of a Sestuike vi Trust is invalid if it does not make plain the status of the relevant beneficiary as dead until their return, including how the certificate may be redeemed and the trust and estate dissolved upon their return. Canon 2045. Since 1933, when a child is born in a estate, under inferior Roman law, 3 Sestuike vi Trusts are created upon certain presumptions, specifically designed to deny the child forever any rights of real property, any rights as a free person and any rights to be known as man and woman rather than a creature or animal, by claiming and possessing their soul or spirit. Canon 2046. Since 1933, Upon a new child being born, the executors or administrators of the higher estate willingly and knowingly convey the beneficial entitlements of the child as beneficiary into the first vi trust in the form of a registry number by registering the name, thereby also creating the corporate person and denying the child any rights as an owner of real property. Canon 2047. Since 1933, when a child is born, the executors or administrators of the higher estate knowingly and willingly claim the baby as chattel to the estate. The slave baby contract is then created by honoring the ancient tradition of either having the ink impression of the feet of the baby onto the live birth record, or a drop of its blood, as well as tricking the parents to signing the baby away through the deceitful legal meanings on the live birth record. This live birth record as a promissory note is converted into a slave bond sold to the private reserve bank of the estate and then conveyed into a second and separate vi trust per child owned by the bank. Upon the promissory note reaching maturity and the bank being unable to seize the slave child, a maritime lien is lawfully issued to salvage the lost property and itself monetized as currency issued in series against the vi trust. Canon 2048. Since 1540 and the creation of the first Act, deriving its power from the papal bull of Roman cult leader Pope Paul III of the same year, whenever a child is baptized and a baptismal certificate is issued, the parents have knowingly or unknowingly gifted, granted and conveyed the soul of the baby to a third vi trust owner by Roman cult, who has held this valuable property in its vaults ever since. Since 1816, this third crown of the Roman cult and third vi trust representing ecclesiastical property has been managed by the Temple Bar and subsequent bar associations representing the reconstituted cull are responsible as grim reapers for reaping the souls. Canon 2049. Each vi trust created since 1933 represents one of the three crowns representing the three claims of property of the Roman cult, being real property, personal property and ecclesiastical property, and the denial of any rights to men and women, other than those chosen as loyal members of the society and as executors and administrators. Canon 2050. The three vi trusts are the specific denial of rights of real property, personal property and ecclesiastical property for most men and women, corresponds exactly to the three forms of law available to the Gala of the Bar Association courts. The first form of law is corporate commercial law, and is in effect because of the first vi trust. The second form of law is maritime and canon law, and is in effect because of the second vi trust. The third form of law is Talmudic law, and is in effect because of the third vi trust of baptism. Canon 2051. In societies controlled by inferior law, when a man or woman physically dies without ever having dissolved their vi trusts, the property of the temporary testamentary trust is conveyed into a permanent testamentary trust and a formal death certificate is issued. Canon 2052. The creation of a vi trust and estate is unlawful if a valid birth certificate is not issued to the next of kin of the relevant missing and presumed dead beneficiary, including clear instruction on how it may be redeemed and the trust dissolved upon their return or reaching majority. Canon 2053. Failure to disclose, or admit upon request the existence of a vi trust instead of beneficiary relationship to an estate constitutes a fundamental breach of duties of any administrator or executor of the estate and a most serious fraud requiring their immediate removal and punishment. Canon 2054. Under their solemn obligations and duties as trustee, it is the sole responsibility at first opportunity of any administrator or executor, not the person before them, to offer remedy and relief to re-establish their competency, living status and return, thus extinguishing any vi trusts and returning any remaining assets to the person. Canon 2055. Upon a person fulfilling the requirements to re-establish their status and competency, the relevant administrator and executor is duty-bound to dissolve the vi trust as it has been proven to have been created on one or more errors of presumption. It is immaterial to the dissolution of any vi trust and estate if a person, upon proving the necessary errors of presumption, returns any or all copies of the birth certificate of the trust and body corporate. Canon 2056. Any administrator or executor that refuses to immediately dissolve a STUEK, vi. trust, upon a person establishing their status and competency, is guilty of fraud and fundamental breach of their fiduciary duties requiring their immediate removal and punishment. Canon 2057. Failure to provide a full accounting of the former estate of a dissolved STUEK, vi. trust, including the return of any remaining assets to the beneficiary, constitutes both theft and fraud by the administrators and the executors. Article 101. Mortgage. Canon 2058. A mortgage is a complex bundle of rights, encumbrances and transactions involving primarily a lease, lien and loan issued through a temporary testamentary trust known as a STUEK, vi. trust under estate law. Canon 2059. The first component to a mortgage is a lease formed through the creation of a STUEK, vi. trust whereby the higher estate such as a state, territory or nation conveys title to the financial institution as landlord and the borrower as tenant. Leases within a standard mortgage are usually fixed in term, such as 15, 20 years and sometimes for even a longer term. Once the lease expires, the STUEK, vi. trust dissolves and title returns to the higher estate. Under modern estate law, a borrower of a mortgage is always a tenant, never an owner. Canon 2060. The second component to a mortgage is a consensual commercial lien issued under estate law whereby a lien is placed upon a real estate deed and title under estate law whereby a lender is granted certain rights to seize title over the real estate property of the borrower, usually only after foreclosure is granted. Canon 2061. As all mortgages now are commercial liens issued under the estate law of securitized estates, it is now the banks and financial institutions that are legally considered the executors and administrators, with the borrowers always considered tenants, whether the loan is fully paid or not. Canon 2062. The third component to a mortgage is the loan, which has two important elements: the principal representing the actual loan itself and the interest, lawfully representing rent of the tenant to the landlord. Canon 2063. Under trust law and estate law, the executives of financial institutions of executors and administrators under estate law are obliged to perform as duty-bound officers of a testamentary trust and not materially alter any conditions of the deed and title which represents a formal will. Deliberate fraud in altering a deed and will constitutes a most grave injury to the whole of estate law of the Roman system, and if uncontested and unrepaired is tantamount to the open consent by the most senior executors and administrators of the highest estates that the whole system is now null and void. Canon 2064. The promissory note and application form signed by a lender as part of a mortgage is material to the deed and will of the estate. Therefore, by estate law, any fraud or deception in materially altering the terms of the testamentary trust immediately disqualifies the executive from acting as executor or administrator with the financial institution assuming full liability. Canon 2065. Any inferior Roman court that openly permits the unrepaired and open fraud of trust law, estate law and the law of wills by refusing to repudiate any financial institution that monetizes or multiplies the sale of a loan without consent or remedy to the borrower openly consents that the whole system of Roman trust law, estate law and wills no longer applies and is null and void. Canon 2066. By definition, any property taxes charged by the higher estate to the tenant are the direct responsibility of the landlord. Where a court seeks to foreclose on a property against the tenant and not the financial institution, constitutes a gross fraud and if unrepaired, is an open consent that Roman trust law, estate law and contract law no longer applies and is null and void. Canon 2067. Equity does not exist in mortgage as the terms of ownership is always a lease. Any claim therefore of equity is a fraud and misrepresentation of contract by the lender and higher estates. Canon 2068. The sale of a home or property merely represents an assignment and then novation of lease, with most mortgages permitting such conveyance providing the landlord of the higher estate can claim some form of compensation from the sale through taxes. Canon 2069. Providing that a financial institution has not committed fraud against the deed and will of the estate under which a mortgage is applied against real estate, the institution must first seek a granting of foreclosure before seizing the property. This is because the lender is their tenant under a fixed-term lease. Article 102 Bond Canon 2070. A bond is a negotiable debt instrument, security, issued against people as property effectively in control of the bond issuer for the raising of capital from a lender called the bondholder on the agreement of paying some form of regular interest payments called coupon and the repayment of the borrowed sum at a later date called the maturity. Canon 2071. Unlike stock certificates, bonds do not confer any transfer of property rights unless the bond issuer defaults on interest payments or the repayment of the maturity. Canon 2072. The word bond originates from 1st millennium BCE Gaelic bond meaning, male, head of household, free-born farmer, with bond meaning base, sole of foot, foundation, source and de meaning as, there, on. In the 13th century and the introduction of Roman feudalism, the word was deliberately Latinized to bondagitum, bondage, meaning to drive, to move, chase, agitate, excite to action, persecute, keep household animals or farm animals. Hence the true and original meaning of bondage as condition of, a man or woman, considered a household or farm animal, a serf, less than a Roman servant. Canon 2073. By definition, a bond can only be issued if the entity possesses some form of official control over one or more persons consistent with the original nature of the word bond and the legal system promoted by the Roman cult. Hence, the primary entities under the Roman Vatican system of law that are acknowledged as having a natural right to issue bonds include, but not limited to, I. Municipalities, councils, possessing hospital and psychiatric control over ratepayers as outpatients living in wards, and 2. State and federal governments as administrators and beneficiaries of the Sestuekvi trusts treating persons as legal slaves and property, and 3. Courts as temporary executors, guardians and trustees of persons who are charged and processed through them. Canon 2074. The three most common forms of bonds are surety bonds, also called bid bonds, performance bonds and payment bonds. All three share the same characteristic, that the amount of the bond is called the penal sum, representing the sum agreed upon in the bond to be forfeited if the condition of the bond is not fulfilled. A bid bond, surety bond, guarantees the owner that the principal will honor their bid and will sign all contract documents if awarded the case. The owner is the obligee and may sue the principal and the surety to enforce the bond. If the principal refuses to honor its bid, the principal and surety are liable on the bond for any additional costs the owner incurs in reletting the contract. The penal sum of a bid bond often is 10 to 20% of the bid amount, and 2. A performance bond guarantees the owner that principal will complete the contract according to its terms including price and time. The owner is the obligee of a performance bond, and may sue the principal and the surety on the bond. If the principal defaults, or is terminated for default by the owner may call upon the surety to complete the contract. The penal sum of the performance bond usually is the amount of the prime construction contract, and often is increased when change orders are issued. The penal sum in the bond usually is the upward limit of liability on a performance bond, and 3. A payment bond guarantees the owner that subcontractors and suppliers will be paid the monies that they are due from the principal. The owner is the obligee. The beneficiaries of the bond are the subcontractors and suppliers. Both the obligee and the beneficiaries may sue on the bond. An owner benefits indirectly from a payment bond in that the subcontractors and suppliers are assured of payment and will continue performance. The penal sum in a payment bond is often less than the total amount of the prime contract, and is intended to cover anticipated subcontractor and supplier costs. Canon 2075. As the primary purpose of all Roman courts is to make money, not to honor the law, generally two bonds are issued and sold secretly for all cases successfully processed are a bid bond and a performance bond. The bid bond is issued usually once an indictment has been entered. The courts will normally not permit the granting of any form of bail bond, a performance bond offset against the same price of the bid bond, until the accused has agreed to be under the control of the court, and, 2. A performance bond is normally a significant multiple of the original bid bond issued after the successful consent of the convicted man or woman agreeing to the sentence, and therefore to the performance of their penalties. Canon 2076. When a child is born under inferior Roman law, the executors or administrators of the higher estate claim the baby as chattel to the estate. The slave-baby contract is then created by honoring the ancient tradition of either having the ink impression of the feet of the baby onto the live birth record, or a drop of its blood, as well as tricking the parents to signing the baby away through the deceitful legal meanings on the live birth record. This live birth record as a promissory note is converted into a slave bond sold to the private reserve bank of the estate and then conveyed into a separate vi trust per each child owned by the bank. Upon the promissory note reaching maturity and the bank being unable to seize the slave child, a maritime lien is lawfully issued to salvage the lost property and is itself monetized as currency issued in series against the vi trust. Canon 2077. While these slave bonds are sold by the executors and administrators by legally claiming the children as chattel of the estate, the contract is nonetheless fraudulent because of falsely obtaining consent and lack of full disclosure. Therefore any claimed rights of the owners of the estate are immediately rendered null and void, with all liability returned to the executors and administrators. Canon 2078. As all bonds created through fraud and defective means under inferior Roman law are null and void, any associated property, currency and monetary value created upon the underwriting of these fraudulent and defective instruments are also hereby null and void. Article 103. Lien. Canon 2079. A lien is a legal fiction first created during the reign of Henry VIII of England, whereby one who is owed a debt may lawfully claim certain rights over the property of another who owes the debt until it is paid. Hence, a lien is a non-possessory property interest over certain assets to secure performance of an obligation, usually the payment of a debt. Canon 2080. The owner of the property against which a lien is placed is called the lender, while the person who has the benefit of the lien is usually called the lienee. Canon 2081. A lien is an encumbrance over the particular property alienated. Therefore, a lien can cause the title held by the owner to be defeated, terminated, annulled, voided or invalidated if the performance of the obligations of the lien are not met. Canon 2082. Under the inferior Roman system of law, property may be affected by more than one lien. The lien that is considered the first lien is the lien that takes priority over all other encumbrances over the same property. The second lien has second priority and so forth for all other liens. Canon 2083. Liens may be regarded as consensual, or non-consensual. A mortgage is a form of consensual lien. A tax lien is a form of non-consensual lien. Canon 2084. Under the inferior Roman system of law, secret liens are permitted to be created against certain property yet kept secret and therefore not appearing on records available to any purchaser or holder of the property, in direct contravention to all principles of law. To reinforce the absurdity and fraud against the very principles of law, these liens are openly called secret liens. Canon 2085. Excluding whether a lien may be hidden or published, or consensual or non-consensual, all liens may be defined according to the level of rights of encumbrance granted to the lienee, namely maritime, agricultural, commercial and judicial. Canon 2086. Under inferior Roman law, a maritime lien is the most powerful of all forms of lien, usually granting the lienee full rights of encumbrance over the property until the debt is paid, often for the purpose of salvage of lost or abandoned property. A valid maritime lien always has higher priority against other non-maritime liens. Canon 2087. A further power concerning maritime liens relates to recovery in the event of a failed salvage of the property, whereby a maritime bill of exchange may be lawfully issued against the value of the lien, which must be accepted for monetization by any bank within the Roman and Western financial system. Canon 2088. As most debt money in circulation throughout the Roman Western financial system is monetized maritime bills of exchange based upon fraudulent secret liens against the citizens of nations as estates. The failure to honor a valid maritime bill of exchange represents a gross breach of the entire financial system, requiring the highest banks to make repair, or through dishonor consent to default the whole system as null and void. Canon 2089 Inferior Roman law permits the deliberate corruption of maritime liens whereby such encumbrances may be placed upon persons also representing vessels. However, under the false claim of the Roman cult, also known as the Vatican, also falsely known as the Holy See, such powers are considered reserved. Canon 2090 The second most powerful form of lien under inferior Roman law is an agricultural lien by the executors or administrators of an estate against a tenant and beneficiary of the estate, whereby a wide variety of encumbrances may be applied, including the lawful seizure of all property held by the person. Canon 2091 The power that permits agricultural liens their legal effect is deliberately misconstrued as statutory law, constituting a deliberate corruption and fraud of the law, negating under all principles of law such liens from the beginning. Instead, the effective power of these liens is the deed and will of the estate and the status of the person as either a beneficiary and tenant or sestuique vius as a beneficiary of the sestuique vi trust, not statutes. Canon 2092 The third most powerful form of lien under inferior Roman law are commercial liens, also using estate law, but through the membership of persons to securitized estates whereby private and commercial entities operate as the executors and administrators and persons remain merely tenants of both immovables and movables. Canon 2093 All mortgages are commercial liens relating to estate law of securitized estates where the banks and financial institutions are legally considered the executors and administrators and the lenders are always considered tenants, whether they pay off their loan or not. Canon 2094 The fourth and least powerful form of lien under Roman law are judicial liens issued by a competent court in accordance with some dispute. Canon 2095 In the argument of priority between liens, a lien may be considered perfected or unperfected. A perfected lien is one in which a creditor possesses the property, or has established a priority right in the encumbered property with third-party creditors, or has registered a claim. Canon 2096 As all property rights come from divine trusts to true trusts and then superior trusts, no inferior Roman official, entity or person has any possible valid claim against a Eucadian trust, therefore any inferior Roman lien issued against a Eucadian trust automatically is null and void. Canon 2097 As the society of one heaven is the one, the only true Holy See, in accordance with these canons and the sacred covenant Pactum de Singularis Caelum, the Roman cult, also known as the Vatican, is hereby solemnly stripped of all ecclesiastical and temporal authority to issue maritime liens, or to permit the monetization of maritime bills of exchange, with all powers hereby lawfully transferred to the Treasury of the Globe Union. Canon 2098 As the society of one heaven is lawfully the first see and the one true Holy See, all maritime liens by which all currency based on maritime bills of exchange are hereby extinguished, with the full liability for underwriting the debt of these liens henceforth due by all the present and previous executors and administrators and their heirs and successors who have been responsible for presiding over this fraud against the divine Creator and all principles of law. Article 104 Easement Canon 2099 An easement is a claimed right held by one person to use the land of another for a special purpose. Canon 2100 An easement is effectively a second form of equitable title offered for lease by the administrators and executors of an estate. The most common example is mining rights. Canon 2101 As a person holding a mortgage never actually owns the land, only leases it, they are generally powerless to prevent the executors and administrators of the higher estate selling separate rights under lease to another party, unless they can prove the activities of the second party will grossly deprive them of fundamental rights of the operation of their tenancy. Canon 2102 The existence of any easement is proof that land ownership within the inferior Roman system is conducted a gross fraud and deception. Article 105 Estoppel Canon 2103 An estoppel is an impediment to a right of action arising from a person's own act, or where they are forbidden by law to speak against their own deed. Hence, to estop is to stop up or impede a person from alleging or denying a fact, because of her own previous act. Canon 2104. The major forms of estoppel are reliance, record, deed, silence and laches. A reliance-based estoppel is when one party relying on something the other party has done or said relies on certain evidence to prove this to produce an estoppel by representation of fact, promissory estoppel or proprietary estoppel. And, 2. An estoppel by record is when the orders or judgments made in previous legal proceedings prevent the parties from relitigating the same issues or causes of action, and no action estoppel or judicial estoppel is issued. And, 3. An estoppel by deed is when the rules of evidence prevent the litigant from denying the truth of what was said or done, and a deed estoppel is issued. And, 4. An estoppel by silence is when a party had the right and opportunity to assert a position earlier, and such silence put another person at a disadvantage. An estoppel by silence may be issued. And, v. A laches is an estoppel in equity by delay. Article 106. Date. Canon 2105. Date is a fictional concept whereby the presence of the word itself indicates either a ceding of rights or a gift by the signatory of a document to the other party. Date comes from two of the oldest words in Latin, datio meaning to give away, one's rights, and dato meaning gift. Canon 2106. By inferior Roman law, when the word date or day is used on a document that is not a deed or agreement and it is associated with a Roman time, this indicates the consent of the author to cede any rights of claim or protest concerning the subject matter contained in the document to the recipient. Canon 2107. By inferior Roman law, when the word date or day is used on a document that is an agreement or deed and it is associated with a Roman time and location, this indicates the consent of the signatory to give any and all rights contained within the agreement to the other party. When both parties sign with a date present, the effect is neutralized. Canon 2108. As the system of inferior Roman law has continued to deceive their own legal professionals as well as members of the general public, the knowledge of the significance of date has been largely lost to only a very few. Canon 2109. Under inferior Roman law, when a party uses date and a Roman time on a document, the recipient has the right to seek an estoppel against any subsequent action by the other party based upon their consent by the use of date to cede any right of claim or protest. Canon 2110. Under inferior Roman law, when a party uses date and a Roman time on a deed, the recipient that did not use date has the right to seek an estoppel against any subsequent action by the other party based upon their consent by the use of date. Furthermore, the same party has the right to seek a judgment to have the property seized based upon the agreement of any property being a gift. Canon 2111. In accordance with these canons, the legal definitions associated with date and day are hereby null and void, with only the meanings associated with time and timekeeping permitted to remain. Canon 2112. Any person who seeks to exploit the inferior Roman law trickery of using date or day to indicate a ceding of rights or gift is henceforth guilty of fraud, and any such cause of action is immediately null and void. Article 107. Taxes. Canon 2113. Tax is a form of charge imposed by the executors and administrators of an estate upon beneficiaries for their use of property of the estate by enforcing the landlord-tenant relationship. Canon 2114. The original principle of taxes, first invented with the creation of large deceased estates under testamentary trusts, was that the landlord, in fulfilling their obligations for the upkeep and maintenance of the land, had the right to demand tenants pay for the estimated loss of value of property through their use, apart from their payment of rent for the right of use. Hence taxo in Latin literally means to estimate or value, loss. Canon 2115. Prior to the fraudulent conveyance of the property of regions and nations into deceased estates and subsequent extension of taxation, the two most ancient form of revenue was the concept of tribute, followed by duty. Canon 2116. Tribute in its original sense was the classic lord-servant relationship from which landlord and tenant was created, wherein the lord through right and force would demand payment from all those who occupied their lands as a primitive form of rent. Canon 2117. Duty in its original sense was the classic control of trade, using ledgers, ports, storehouses whereby no goods would be permitted to be purchased, sold, imported, exported or transported unless the duty was paid. Canon 2118. The inferior Roman system of taxes as adopted by most nations as estates is predicated on fraud, operates on fraud with no desire on the part of inferior persons acting as executors and administrators to divulge the true method by which the payment of taxes is enforced in inferior Roman law. Canon 2119. Under the modern inferior Roman legal system, almost all revenue of an estate is now classed as taxes, which is both confusing and deliberately misleading. However, from all the variety of taxes, there exists just three base forms of tax, being rent tax, compensation tax and duty tax. Canon 2120. Rent tax is the deliberate fraud of misnaming rent charged to a tenant by the landlord, being the executors of the deceased estate of the province or nation, for use of some property. Both income tax and company tax are forms of rent taxes. Canon 2121. Income tax is a rent tax by the executors of the estate for use of their property in the form of the dead body corporate, also known as a corporation of the sestuique, vi, trust formed on the presumption that the beneficiary is dead, abandoned, a minor or incompetent. Canon 2122. A further element used to enforce the payment of taxes is the false, secretive and misleading legislative treatment of the members of a society as aliens and enemies to the society. Therefore all criminals since the 1930s in the United States and later for other nations. The forced requirement to register for a tax number is therefore the admission that one is to perform criminal acts for a given period, and then a license is granted, usually for 1 year on the provision of self-confession. Canon 2123. Modern Roman tax collection systems treat each financial year as a separate testamentary trust and therefore each year equivalent to a separate court case whereby a taxpayer is compelled to confess any crimes against their society in a return each year, or face serious criminal charges. Canon 2124. When a person has re-established their competent living status, then by law the sestuique, vi, trust is dissolved and they return to being acknowledged a beneficiary or a some higher standing if a trust. In either case, it is both unlawful and a serious fraud against the law to seek income taxes once the sestuique vi is dissolved and no dead body corporate exists to use as argument for rent. Canon 2125. Whilst Roman societies force their members to admit to being taxpayers, there is no remedy in Roman law in remaining a registered taxpayer other than admitting to criminal acts under the perverted Roman laws in place within most nations. Canon 2126. Company tax for non-public companies is a rent tax by the executors of the estate for use of their property in the form of the dead body corporate, also known as a corporation of the sestuique, vi, trust formed on the presumption that the directors as testators are already dead, because of their previous relationship to individual sestuique, vi, trusts. Canon 2127. When a person has re-established their competent living status, then no sestuique, vi, trust may exist in their place. Therefore, a company must be formed as a trust instead of a sestuique vi, and company tax cannot be charged for rent under its present form. Canon 2128. Compensation tax is a classic form of tax based on the right of the landlord to demand tenants pay for the estimated loss of value of property through their use. Property tax is an example of a compensation tax. Canon 2129. Duty tax is a charge demanded upon the deposit, withdrawal, purchase, sale, import or export of any goods by any tenants of the estate. It is based on the ancient argument that all chattel and immovables belong to the land, therefore by extension are owned by the landlord. Canon 2130. Tax is not the first, the best nor only method of a government of a society raising necessary revenue for the upkeep and well-being of the whole society. Canon 2131. It is the obligation of all members of a society to contribute some of their energy and wealth towards the well-being of the society. However, the inferior Roman system of tax law is corrupt, fraudulent, inefficient, grossly unfair and unsustainable. Canon 2132. While all governments have a right to seek revenue and contributions from their members, the extraordinary fraud and continued deception and fraud that is required to keep the inferior Roman system of tax operating, negates the validity of claiming the law. Instead, all systems of revenue based in inferior Roman tax law are null and void from the beginning. Article 108. Foreclosure. Canon 2133. A foreclosure is a formal hearing relating to a standard mortgage requested by a financial institution or interested party to deprive a tenant of their right of redemption, also known as equity of redemption, declare them delinquent and therefore terminate their tenancy without legal recourse, permitting them to be legally evicted. Canon 2134. Delinquency is not merely the failure to perform the obligations specified under a lease, but the failure to provide any form of considered attempt to perform. Therefore, a tenant that continues to perform under severe financial difficulties, even if the amount is grossly under their original obligations, cannot be considered delinquent and foreclosure is unlawful. Canon 2135. Foreclosures are equivalent to the court process of replevin, also known claim and delivery as part of repossession of other leased property. Replevin is a formal hearing requested by the owner, lessor, against the user, lessee, relating to a form of goods the owner seeks permission to seize. Under the laws of most estates, a replevin is required before seizure. Canon 2136. In accordance with inferior Roman trust law, estate law and law in general, a foreclosure hearing and many replevin hearings are a deliberately fraudulent act conspired between the financial institution, interested party and the courts to deliberately conceal the nature, function and remedy available to the tenant and lessee and encourage delinquency. Canon 2137. In the first instance of gross fraud relating to foreclosures, the borrower, also known as the mortgagor, is not made aware by the court, nor the financial institution that by a standard mortgage deed and title they are in a fixed-term lease with the institution as a landlord. This alone should be grounds for any foreclosure to be dismissed on grounds of concealment and misrepresentation. Canon 2138. In the second instance of gross fraud relating to foreclosures, the borrower is not made aware that as a tenant under a fixed-term lease, their obligation is to pay the rent to the landlord representing the interest. If a tenant were to make good part or all of the arrears in rent, then by contract law, their fixed-term lease cannot be terminated as a delinquent tenant, even if the principal of the loan remains outstanding. Furthermore, a long-term tenant normally has the right to make remedy of any arrears even after dispossession and regain possession of the property. These remedies is what is known as the tenant's right of redemption or equity of redemption. Canon 2139. In the case of actions of replevin and repossession, the lessee is rarely made aware that they do not, nor ever will own the asset, especially in the case of motor vehicles, and that as a lessee, their primary obligation is to pay the rent on the asset in the form of the interest. If a lessee were to negotiate the terms of their rent and still pay, then almost all actions of replevin and repossession are unlawful. Canon 2140. In the third instance of gross fraud relating to foreclosures, the borrower is not made aware that their property is held in sestuique, vi. trust, being a temporary testamentary trust, and so it is the financial institution that is responsible for all property taxes being rent charged by the landlord being the state or county to the leaseholder being the bank. Canon 2141. In the fourth instance of gross fraud relating to foreclosures, the borrower is not made aware by the financial institution of any material alterations to the deed and title made by the institution, particularly in non-selling or reselling the mortgage and recouping their loan. As the material alteration of a deed and will of a testamentary trust is a most serious breach of fiduciary duties, This fact alone should be grounds for a foreclosure hearing to be dismissed and any contract claims by the institution rendered null and void. Canon 2142. Whenever an inferior Roman court has permitted the complete and deliberate corruption of the most basic tenets of Roman Western law by permitting foreclosure hearings to proceed, the courts and law officers through such overwhelming fraud consent and agree by their actions that all forms of Roman law, Talmudic law and other inferior law has ceased to exist and is null and void. Canon 2143. Any person guilty of participating in the gross fraud and corruption of law through the manner described by foreclosure consents and agrees they are personally liable to all future penalties and reparations, punishment and consent and agree they are without any lawful authority whatsoever.